Dr. Richard Izquierdo, Associate Professor of Political Science, teaches courses in American politics and law at New College of Florida, where he is also the Director of Pre-Law. Prior to a career in academia, he earned his J.D. at the University of Pennsylvania Law School and practiced law at Fried, Frank, Harris, Shriver Jacobson in New York City. Try saying that 5 times fast. He left the practice of law to earn his Ph.D. in political science at Stanford University. After graduation, he was the Thomas W. Smith Postdoctoral Research Assistant at Princeton University, and then was the Constitution Fellow and Visiting Lecturer at Georgetown Law.
Thank you, Casey. One of the wonderful things about this project is that we get to sort of look at how America was made and how America was made very differently. It's one of the things that has always attracted me to the study of America. Like our fellow panelists, we each look at America through different lenses, but all through a kind of common language, which is really kind of fortunate. And so in thinking about this, I have to give credit to my colleague, Professor Wheatland, because he sort of kind of named the big 4: nature, reason, liberty, constitutionalism. These are kind of concepts that, although we might take it for granted today, had real resonance and meaning. And hopefully, I kind of get the gist out, it has meaning among this crowd. But I want to sort of say a little bit more about how unique the project of American constitutionalism was and what the contribution really was in showing you one example that highlights everything. So one of the things that I always think is really interesting about anybody who studies American constitutional law is in the first few days, you read the US Constitution. In most American law schools, that's usually the first subject. And then you get to Marbury versus Madison, maybe McCulloch versus Maryland, and you start to go into the cases, right? But what is special about America is that you don't just run a drift of cases like on an ocean. There is a real core there of what we're trying to get back to. And I want to talk about how unique and special that was among the founding generation. And I can do this through talking about one provision of the Constitution. I'll tell you what that is. But one of the things that's really great about this America at 250 project is that we're talking about the great periods where we have foundations and we have some transformation over time. Some of these transformations are consistent. Some of these transformations are not consistent. I'm going to talk a little bit about all of that in my talk today. So one of the things that I always tell my students whenever I get the opportunity to teach anything related to this is that at the American founding, ideas were a very practical subject. In fact, foundational ideas were a very practical subject. They were very necessary. And I think our US Constitution does this in 2 ways. The first way is that it preserves liberty. Liberty is like what the Constitution was made to preserve above all else. And then secondly, it's the political science, the methodology in which you preserve that liberty. We even see this in Philadelphia in 1787. The 2 most quoted philosophers in Philadelphia in 1787 are John Locke. He's the second most quoted. He's quoted for different reasons than the first most quoted. John Locke is quoted for liberty, ideas of property, ideas of liberty, tolerance in religion, liberty of the individual, all of those sort of things. And the first most is a Frenchman. It's Montesquieu. And Montesquieu is quoted for his political science, how you arrange institutions to protect that liberty. That's very unique about this subject. So one of the things that's great about teaching here at New College is that we have very low barriers between things like political science, law, history, philosophy, economics. I think the founders came from that tradition. That's always what attracted me to that. So a little bit about how tough the task was. So James Madison goes to Philadelphia in 1787, and there's already a failure. There's 2 failures, one much larger than the other. The Articles of Confederation seemed to go like most Republican experiments have been going. A good try, but it's not very successful. It has a lot of problems. It's good-natured, but it's kind of like a league of friendship between the states. They understand this, and they go to Maryland and Annapolis, and they try to fix this idea, and they don't even have enough to have a quorum. So they're gonna like come back, do it all in Philadelphia. James Madison uses his time really wisely. And although this conversation is about one idea he made, I just want to give a slight background on what James Madison does. James Madison asks his good friend Thomas Jefferson, who's not in Philadelphia, he's in France during the Constitutional Convention that summer, and he asks him, can you send me like the best books on republics? Jefferson, good friend of his, does so, looks at republics, both classical like Rome, more modern. What are the modern republics he's looking at? Modern day Poland. Poland was like twice as large as it is today. If you ask any Poles, they'll tell you how rich their history is and stuff. It doesn't start in the 20th century. It starts way before that. The Netherlands, Switzerland, and they have one thing in common. They don't provide many beacon lights because republics tend to fail. So representative government fails. This is a difficult undertaking. So this is trying to get something right under fire. No one who comes to Philadelphia in 1787 thinks they're going to write a new constitution. I often tell my students on the first week and a half of class that there's something, when I used to practice law, we called first mover advantage, that whoever kind of goes first gets an advantage, and that like everybody has to react to it. So they're all coming, they're thinking they're going to amend the Constitution, except Jimmy Madison. He had read all about republics, and he thinks that the articles aren't going to make it. We're going to go the newest example of a failed republic, and he has the Virginia plan. And this is a deft piece by James Madison. He goes first. And so while it's shocking to the other delegates, they have to react to it. I always tell my students, look at the counterfactual. What if I'm from New Jersey, my fellow Jerseyan William Patterson went first with the New Jersey plan? We probably wouldn't have had the US Constitution. It's really a deft move by Madison. Madison's like really thinking really a few steps ahead. It's commonplace to say somebody plays chess while others play checkers. They used to say that about Larry Bird, how he played basketball, but I think it really is true with James Madison. So I think there's many ways I could take this, but I chose, and this wonderful opportunity that I'm grateful for New College for giving all of us, to talk about the Ninth Amendment. I've never given a talk on the Ninth Amendment. I'll be honest, it's my favorite amendment. And it's an amendment that doesn't even have much power, much sway. There's never been a Supreme Court case, either at the federal or state level, that has been overturned because it violates the Ninth Amendment. But I like it for a lot of reasons, so we're going to talk about it. I believe that the Ninth Amendment really gives us insights into like what I like to think is that the founders brought into the project that they're doing, both in 1776 with the Declaration and in 1787 with the Constitution. I do think that there's great continuity between those. A lot of historians try to say, like, yeah, they were more Lockean during the Declaration and more Blackstonian during the Constitution. I don't believe that. I think there's a million amounts of evidence about, like, if you read the state constitutions in the 1780s, all of this, it's overwhelming. I don't want to bore you, so I don't want to go into that. But what I do want to talk about is the Ninth Amendment. And I think it gives us insights to what I call the presumption of liberty. One thing that's really interesting about the Ninth Amendment, it's part of the Bill of Rights, but it's not its own right in and of itself. In fact, its author, as I will mention again, was a very reluctant writer of the Ninth Amendment, or the Bill of Rights. He was a member of Congress from Virginia, and kind of as a promise after the ratification, he agrees to sort of write these, right? And so, the first time they even talk about a Bill of Rights in Philadelphia is like late in September, when the convention is almost over. And so we have different views about why they don't do that. First of all, from our modern ears, we're like, why wouldn't they want a Bill of Rights? Bill of Rights is kind of like if you ask the modern American today off the street, she or he will say, it's the First Amendment, freedom of speech, all these sort of things. And there's much to be said for that. But the project that they did in Philadelphia, one of the things that was special about it is that they thought they figured out a way to limit government and to preserve freedom. Alexander Hamilton, Federalist number 84, said a Bill of Rights would not only be unnecessary, but dangerous. I want to talk what that means, really. Unnecessary, but dangerous. But in another sort of way, before I get into delving into that a bit, he also says, and this is very telling of Alexander Hamilton, which in my opinion, no matter what you think of Hamilton, he was the most prescient of the founders. The country that we actually came into being is closest to what he had in mind. And Hamilton says the Constitution in itself is in every rational sense and in every useful purpose a Bill of Rights. Why is that? Well, that goes to the first thing about unnecessary. Basically, this is kind of foreign to our 2026 years. It's even foreign if it was like 1966. Essentially, the idea of the founding generation was like, we're going to give government some powers, and guess what? If we don't give you that power, you don't have it. So that's an arrangement. That's the political science and substance. I always go back to that. Substance, liberty, methods, political science. They're trying to do that in one. He's not uncommon in that point of view. Madison shares that to a large extent. Dangerous. All right, so that's why they're unnecessary, right? You don't have to, all of us don't want to do something that's redundant. If we've already done it, we don't want to do it a second time. Dangerous, and this is really important, because to list them was to limit them. So Hamilton, always very smart and sort of understanding what's a couple of steps ahead. It's impossible to compose a compendious, satisfactory list of all rights. Incomplete enumeration would imply that items left off the list were no longer recognized as rights. That's not a small critique. I would submit to you, having taught both American politics and American law, being in the thick, I think if there wasn't a country called America, I would be unemployed today. So essentially, like, that heart of that insight, if you ask anybody who teaches, like, who studies the American constitutional law or American politics, is like, yeah, they'll cite off, like, what our Bill of Rights says, what anything else. And if it doesn't say it, if it's not explicitly mentioned, we don't have it. So that's a pretty interesting insight. Like, I always go to the founding. All right, now I'm going to give you a person from the founding that you may not know as much about. And in fact, he's often not the most pro-liberty guy. This is James Iredell from the state of North Carolina. James Iredell at the ratifying convention, so they've already come to Philadelphia and they're getting back to North Carolina for the ratifying conventions. You need 9 out of 13 votes to ratify the Constitution. North Carolina is one of those, obviously 9 of the 13 states. And James Iredell says, it would not only be useless, but dangerous to enumerate a number of rights which were not intended to be given up, because it would be implying in the strongest manner that every right not included in the exception might be impaired by the government without usurpation. And it would be impossible to enumerate every one. Let everyone make what collection enumeration of rights he pleases. I will immediately mention 20 or 30 more rights not contained with it. That's almost the most kind of liberty statement that I've ever heard James Iredell say. And it's a very true statement. If you doubt this, what he's trying to say is, like, it's really hard to come up with a list. Let's say your top 20 rights. If you ever have the opportunity to do so, why don't you, with somebody you trust who likes liberty and government and politics as much as you do, and, have, like, a day in which you write your 20 most essential rights, 20, not 10, 20, and then the next day flip them to each other. They will almost never be the same. And essentially, what that's getting at is to write all of these most essential, you're going to miss out on things. And this, particularly in 2026, my students bring up great questions about privacy, and I bring them back up, and all of these sort of things and stuff. So that's a really telling statement by James Iredell. I'm not the biggest Iredell fan, but that's a really good statement. Now, I am a fan of the next person, James Wilson. Why am I a fan of him? Because James Wilson is the first law professor in the United States of America. He's from Pennsylvania. He's a member of the Constitutional Convention. He's the first professor of some place called the College of Philadelphia. The College of Philadelphia would become the University of Pennsylvania, and I'm biased. An alum of their law school, I'm a fan of James Wilson. But I would have been no matter what. He has a couple of statements that start to really hone in on the task of liberty at the founding. James Wilson says government should be formed to secure, to enlarge the exercise of natural rights in its members, and every object which has not this in view and as its principal object is not a government of legitimate kind. Okay, that's substance. That's full agreement. But check this other statement out that James Wilson says. In trying to get that end, he says a Bill of Rights annexed, added to. And by the way, we take it for granted that the Bill of Rights is just added at the end of the Constitution. That wasn't totally consensus at the time. There were many who thought that it would be like, imagine you're doing a paper and you're editing it in Word and you're taking out words and putting phrases in. That could have been Amendment 2. The fact that we don't have that and we have it as a list at the end is kind of interesting because that wasn't secured. But he says that a Bill of Rights annexed, added to a Constitution, is an enumeration of the powers received. If we attempt an enumeration of everything that is not enumerated, it is presumed to be given. The consequence is that an imperfect enumeration would allow all implied powers into the scale of government, and the rights of the people would be rendered incomplete. A lot of these arguments are, if you name rights, is the implication that what you don't name, you don't have those rights? I always tell my students, one of the things that law often does is things by implication, right? Like reference or something like that. For example, an example I would give, I sometimes get asked to do a recommendation letter. And what if I wrote a recommendation letter that says for somebody named Jimmy? Jimmy was very punctual to class and always polite. Sincerely, Richard Alexander Izquierdo. Right? That's not a negative letter. It's good to be polite and on time. But what am I not saying about him, right? There's always implications. So if you list these rights, is the implication that if they're not listed, they don't go up to that level and they don't have the same thing, the same kind of precautions and preservations to them. James Madison, a reluctant writer of the Bill of Rights. So that's how I always find that interesting. He's kind of reluctant because he's kind of doesn't think it's necessary. He's not against it, but he's not kind of thinking. And one of the things that James Madison is cautious about is I will write them, but I don't think it's the number one thing I need to do. So now we're going to talk about the Ninth Amendment. The Ninth Amendment, like all of the Bill of Rights, is pretty simply stated. And I like it because in one sentence, it does a lot. And if you study the Bill of Rights, one of the things that the Bill of Rights is really obvious to anybody who reads the first 8 provisions of it is that these are rights that keep a tyrannical government at bay. It's kind of like what they are. I once heard the late Justice Antonin Scalia, in a talk he gave in New York, say, the best way to understand the first 8 amendments of the Bill of Rights is what would a tyrant want, and how do you prevent the tyrant from getting that? So a tyrant wouldn't want you to have free speech, free exercise of religion, you make criticisms of the government, definitely would not want the Second Amendment. I mean, give me a break. The Second Amendment, like a tyrant definitely does not want a Second Amendment. The 20th century sort of shows us kind of like the first thing tyrannical governments do is take people's guns away. Would want to quarter troops in people's homes to see what you're up to, right? But look at, all right, so those are the 8, right? So the 8 are better understood as kind of like limits on a government, but what about all the things that Americans today, if you wake them up, they really kind of like conceive of these things as like what makes them free. The right to earn useful information, education, the right of parents to raise their children as they want, the right of association, the right to travel, the right to engage in useful pursuits of my knowledge and whatnot, the right to even make mistakes. All of the things that you really understand as freedom are never covered in any of the 8 sort of First Amendments. And so I think this is where the genius is in Madison. And I think this is like somehow today a kind of small tale of how we in 2026 are living in a country that is kind of blessed to have that sort of first take on things, but we have a little bit of a different understanding, and I think I can make that clear by talking about the Ninth Amendment. The language of the Ninth Amendment says as follows, and I quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." That's it. Now, drafted by Madison, again, he reluctantly wants a Bill of Rights. And actually, if you like the Bill of Rights, you probably have to give some credit to the Anti-Federalists who kind of like pushed towards that edge. And I often tell my students, don't think of the Anti-Federalists as like people who lost out in the debate or as cranks. A lot of the things that they actually warned about came to being, that America would have a larger military. One of the things about American exceptionalism is America, until the Cold War afterwards, always had a fairly small military, and it always had a draft. That federal courts, the Anti-Federalists said, would overrule state courts. Congress would come to tax heavily. All of those things came to pass. And so I think oftentimes the Anti-Federalists, by giving the name Anti-Federalist, is kind of the people that came up short. I often tell my students states' rights advocates is kind of like a better kind of understanding of them. Okay, so Ninth Amendment. I just mentioned a little bit about it, what it was. I'm going to talk a little bit right now about the structure of the Ninth Amendment. The Ninth Amendment is not an enumerated right. It's an unenumerated right. It's not saying that parents have the right to raise children. It's not saying that you have the right to travel. It's not saying that you have a right to association, a right to contract, a right to anything. The things that if they took it away from us tomorrow, we would sort of see as like taking away what we really consider as liberty. Basically, James Madison, the genius in this provision is that it's a catch-all. How do you do something when everybody is wondering, if you don't put all of these rights, which is an impossibility, how are you going to capture it? So it's a catch-all provision, but it's also a provision that states what America is about. The natural rights baseline, that because you come into civil society, the root of those is still those natural rights. A few other things about the Ninth Amendment. The Ninth Amendment, like all of the Bill of Rights, only applies to the federal government, not the states. Barron versus Baltimore would further effectuate all of these things about the Bill of Rights not applying to the states. After the 14th, through the idea of incorporation, they do come to the states, but not at the beginning. And again, Madison understood the difficulty of the task, what liberty rights to include. James Wilson, again, to list them is to limit them, the implications of that. And the real possibility that, when you do this project, you have to have something that is cohesive for the country. I look at the Ninth Amendment as one of our clues and insights into what I think that the founders had as a presumption of liberty. I'm going to talk a little bit about that. One of the fun things about understanding law and how it relates to politics is because it gets you inside the mind of the founders, I think. And the mind of the founders were that presumptions and baselines were really important. So one of the things that in modern times, both conservatives and liberals have had a tough time figuring out, what's this mean, right? Like, we have the history, we have the catch-all provision, but even if you believe the text of the Constitution, how is it going to be implemented in a way that's kind of meaningful? And both the right and left have had problems with this. Yale law professor and DC Circuit Judge Robert Bork, during his Supreme Court confirmation hearings in 1987, called the Ninth Amendment, when asked by it, a forgotten amendment, and famously stated, and I'm quoting the great late Justice Robert Bork, not Justice, Judge, "I do not think you can use the Ninth Amendment unless you know something what it means. For example, if you had an amendment that says Congress shall make no, and then there is an ink blot, and you cannot read the rest of it, and that is the only copy you have, I don't think that the court can make up what might be under the ink blot." So Madison is reduced to an ink blot. This is a very constituted, very smart professor, right? Kind of interesting. So I just want to sort of say, so why did the late Judge Bork say that? I think Judge Bork simply reflects the wider sentiments of both judicial conservatives and judicial liberals. Both camps have narrowed the meaning of the Ninth. There's some fear of the Ninth. It's like a Pandora's box. What will you open up? Like, what kind of things? And then the justiciability, right? Some rights are enumerated. They deserve protection for sure. What about the unenumerated rights, right? It talks about these rights. And is it proper for courts to identify them? Notice, one of the things about constitutional law that's always fascinating to me is that we have two American principles in almost every constitutional law case at once. You have liberty or natural rights, or liberty rights, civil rights, any kind of rights, you know. And then you have the ability of governments through the representatives to enact laws. And courts and political players have to decide what is that boundary line. So let's talk just slightly about the mandate of the Ninth. And I just want to offer kind of how the Ninth is a little bit of a hint of the Constitution we used to have, and how in 2026, the task of constitutionalism, and especially in a beautiful program like this where we have 3 years to talk about what was founded, how it's transformed, the mandate of the Ninth, and how the Ninth is a kind of like hint on what we have. So we start with the text itself. Again, the text says that the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Others retained by the people, that refers to our natural rights. When you come from the state of nature into civil society, you trade in your natural rights for civil rights. There's also a reference to the natural or liberty rights retained by the people when forming a government. Not any rights claimed can be claimed under the Ninth Amendment. They have to be historically rooted, philosophically consistent rights. And only these rights which are historically rooted should be given some existence, but that still doesn't really solve our problem. Problem that judges always have is if you have enumerated rights, we understand what those are. What about our unenumerated rights? So I want to conclude this with one kind of like message of how we can go forward in looking at this and looking at what the project, if you're intending to recover our constitutionalism, one of the things that needs to be recovered is our foundations. One of the things that the New Deal did really successfully is that the New Deal really challenged the foundation of nature. The foundation of nature, which was really shared by all of the American founders, and Abraham Lincoln, when he's the Republican Party, which forms in 1854 and gains its first election to the presidency in 1860, has things about nature and natural rights all over its party conventions. And even the drafters of the 39th Congress drafting the 14th Amendment, they're all talking about nature, right? And if you're talking about constitutionalism and you're talking about our American baselines, nature is the very quintessential American baseline that makes everything really interesting, very different, very exceptional, as scholars who study America always look at. What is the one difference is that the New Deal really has a kind of foundation in progressivism that is very different. And the progressive foundation sort of says that government can be extended to do a lot of things that it had never been able to do before. So getting back to that idea is a project that the Ninth Amendment always kind of like very silently is like a tap on the shoulder. Like, we have these natural rights. These are our natural rights traditions. And our natural rights traditions in America really are talking about what American politics and American law really was beginning at the first breath. And I'd like to conclude it with this. One of the things that the American founders sort of understood was that if you start with the idea of liberty, that's not the end project. Liberty has to have a philosophical basis, a historical basis, and it has to have a people understand the common language. I will submit to you that in the 3 years we're doing this project, part of the essence of this project is to recover some of that common language. Thank you very much.
Join us in falling in love with America again.